I now recognize Mr. Goldman for 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch.
All right, pause it right there. What you just watched is a textbook example of what serious constitutional oversight actually looks like. No theatrics, no cable news talking points, just representative. Dan Goldman methodically walking an executive official back to first principles, the Constitution, the separation of powers, and due process under the law. This exchange matters because it exposes a growing problem in Washington: executive agencies deciding outcomes first and justifying them later, even when the courts say otherwise. Goldman isn't defending a person. He's defending a process. And that distinction is critical if the rule of law is going to mean anything at all. Before we break this down fully, make sure you like this video, subscribe to Capital Clarity, and share this clip, because moments like this rarely go viral on their own, and they should. If you care about constitutional governance instead of political convenience, stay with me. Now let's get into it.
I now recognize Mr. Goldman for 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that, notwithstanding your statements under oath here today, that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence... So you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary, I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him.
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
So
sir, and he is not.
How can
in
you
this
say he's
country
been
anymore.
treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately. Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
No,
is
no, no, no.
investigators and law
That is
enforcement
you
officers
making
and
that
the case they built
determination.
against him. If you don't
The
trust our law
court
enforcement
has
officers
considered all that.
and
The judge has
investigators,
considered all that,
then
Madam
who do you
Secretary.
trust if you
And
don't
if you would be
trust judges?
quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What
If he were to come
steps
back,
have
your
you
advocacy-
taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court
who
order
has terrorized
says
people
that
in
you
traffic
must take
with human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution.
Gentleman's
and you
time
should
has
fight too for due
expired.
process.
The gentleman's time has expired. I now recognize...
What representative Dan Goldman did here was strip away the noise and force the conversation back to basic civics, and the fact that this even had to be done tells you how far off the rails the discussion has gone. Goldman starts with a simple question that no senior executive official should struggle to answer. Who interprets the law, the judiciary or the executive? That's not a trick question. It's the foundation of American government. And once the Secretary effectively concedes that interpretation rests with the courts, everything else that follows becomes unavoidable. Because here's the core issue. The Supreme Court ruled 9-0 that Mr. Abrego Garcia was not afforded due process. That is not ambiguous. That is not partisan. That is not optional. A unanimous Supreme Court ruling is the highest legal authority in the country. Yet the administration's position, as revealed in this exchange, boils down to this: we believe is MS-13, therefore our actions were justified. And Goldman correctly shuts that down. Belief is not adjudication. Allegation is not a verdict. And executive confidence is not judicial authority. Goldman even concedes something important, something many critics conveniently ignore. If Abrego Garcia is in fact a verified MS-13 member, the law provides mechanisms to remove him. Goldman explicitly says he would support deportation if it's done lawfully. That destroys the bad faith narrative that this is about defending criminals. This is about who decides. And that's where Judge Wilkinson's opinion becomes crucial. A conservative Fourth Circuit judge, no ideological ally of Goldman, clearly states that even if the government's allegation might be true, due process still applies. That's not a loophole. That's the Constitution working as designed. What's striking is how Goldman keeps bringing the Secretary back to the same point. You don't get to decide this unilaterally. Law enforcement opinions, agency determinations, internal findings, all of those must ultimately be tested in court when someone's rights are at stake. And when Goldman asks the most important question, what steps have you taken to comply with the Supreme Court's order, there is no clear answer. Just deflection. Just repetition. Just assertion. That's a problem. Because the Supreme Court didn't say acknowledge. It said facilitate. That's an active obligation. It requires action. And Goldman is absolutely right to press on that point. Court orders are not suggestions. They are binding. The attempt to flip this into an emotional attack, accusing Goldman of fighting for terrorists, is telling. That's what happens when legal arguments collapse. You replace law with outrage. But Goldman doesn't take the bait. He stays locked on process, precedent, and constitutional authority. That's what real oversight looks like. Not grandstanding. Not slogans. not selective respect for the courts. Whether you like Dan Goldman's politics or not, this exchange should concern anyone who believes the executive branch does not outrank the judiciary. Because once we accept that the government can ignore unanimous court rulings based on its own assertions, due process becomes conditional, and that should alarm everyone. This wasn't about one individual. It was about whether court rulings still matter when they're inconvenient. And thanks to this line of questioning, that issue is now on full display. That's clarity. That's accountability. And that's exactly why moments like this belong under capital clarity.